The next case that's come before the court is State of Ohio versus Mary Duffield. And both sides here, ready to go?
Yes, Your Honor.
All right. We're just like a minute early, so you're ready, we're ready. You each will have 15 minutes, and the appellant may reserve up to 5. Come on up to this one, yes, please.
Good morning, and may it please the court, I'm Attorney Noslot, representing the appellant today.
Would you like to reserve some time?
Yes, I would, Your Honor.
How long would you like?
5 minutes.
That's it. Thank you.
Thank you. Today is a great day in the state of Ohio because there's something seriously wrong with our law, and today we have the power to fix that. What's wrong with our law in Ohio is the treatment of people's rights to have their records sealed or expunged. In the case of Pepper Pike, some decades ago, the federal right to have our records sealed due to our federal right of privacy was recognized. In the many cases that have followed Pepper Pike, however, there's been an artificial contraction or contortion, I would say, of applying the federal law in the context of a person standing before the court asking to have their federal rights preserved. The statute only codifies the common law. It cannot replace our federal constitutional rights. The state may give its citizens additional rights. It cannot lower the level of rights that we are guaranteed under the federal Constitution. Yet this is exactly what the state of Ohio is doing in the way that Pepper Pike, paragraph 2 of the syllabus, is being applied. My position exactly was set forth quite nicely by Justice Pfeiffer in State versus Radcliffe, that was before the Supreme Court January 28th of this year. It is the dissenting opinion, I argue, that is the correct opinion, because only seen in that light are these cases being decided against the backdrop that's mandatory, which is the federal Constitution. Pepper Pike and its progeny have just limited its decision and its analysis to the language in the statute, the way it was first written under 2953-32, the way it was amended in 2953-52 to include people that would like their records sealed when they've not been convicted. And since then, we've seen some other cases come before the court when the statute was silent. Namely, in State versus Radcliffe, the issue was, can this person have their records sealed when they've been pardoned? The court wrongly concluded, no, it can't. Looking only at the confines of the statutory walls it has built for itself, based on these two statutes, ignoring and in complete disregard for the fact that federal laws aren't superseded by Ohio statutes or any State of the Union statutes. However their intent might be, however careful they may draft a statute, it cannot impede constitutionally fundamental rights, things that are set forth in the Constitution. So I, in other words, say, even though a defendant, whereas here, is not eligible for the expungement or sealing of the record because they cannot meet Ohio's statutory definitions and terms, there is another question, and it's the judicial remedy of expungement under the right to privacy. We flirt with it in Pepper Pike, and then we kind of go backwards with it, all the way up into the recent case that held, and it just feels irrational, doesn't feel right, and the majority struggled with it. In that case, the defendant had a prior 27 years before, had led an exemplary life, was given a pardon by Governor Strickland, and still stand before the Supreme Court, can't get that record expunged. What does the right to privacy mean then, as set forth in the Constitution?
Well, I guess I'm wondering, are you arguing that the statute as applied is unconstitutional in this case, or are you arguing that the court has an inherent right separate from the statute to order the sealing of the records?
Both, because I feel that that's sort of the same thing. It's unconstitutional because it's not looking at the inherent federal backdrop.
Aren't you asking the court then to essentially rewrite the legislation? And shouldn't the legislature do that?
No, the state is free to make its own statutes, and
The state is, but the courts don't make statutes.
but the court follows the federal constitution. And the state can write legislation, but it's always restricted and operates in the background of federal laws. You can't write a statute, however great it's written, whatever your public policy, whatever your intent might be, if it effectively erases a right that you have under the Constitution.
But then the legislature would be in charge of rewriting that law. Correct?
No, the court has its inherent power, and I say a duty, to uphold a person's federal rights here. Even writing the statute the way that it's written out, it's fine as far as it goes, but it's its application that's being wrongly applied. When we look at Pepper Pike, it states exactly, in special and unusual circumstances, a person may, even though they're statutorily ineligible, may have the right to have their record sealed because of the right to privacy. That's exactly the case. So the statute is codifying common law, is codifying the right to privacy. We see that because why? They're doing the balancing test. That's exactly the federal standard. Weighing on one hand a citizen's right to privacy and to not have their life unreasonably intruded upon by the state, and on the other hand, the state's legitimate reason to keep records for a long time. So it is a codification of the federal balancing test that we use when we analyze all Federal Rights Act issues. To have it applied or to be interpreted to be applied, or even if it was intended to circumvent and limit when that balancing test can be applied, it isn't constitutional. So, in upholding this person's right to have her record expunged or sealed, it's because it's an exercise of her federal right. It's a judicial recognition of that. There's two paths lead to expungement. One is the statutory path, the other being the judicial path. Nothing has abrogated the judicial path. Pepper Pike got it right, recognized that there's two ways. So if you're eligible, you can go under the statute, you're going to get the same relief. But to the extent that the statutes read to be narrow and circumventing the federal backdrop, your federal right, it's being artificially constricted.
And so, what is the standard? What do we look at in your client's case to justify the decision that her right to privacy is being abridged under the First Amendment that separates her from any other individual who is ineligible to have their record sealed under the state statute?
Yeah, under the state statute and the federal statute, it's the balancing test. State statutes can define it to be unique and special circumstances. Those words don't appear in the federal context. It's merely the balancing test. But there are unique circumstances present here. The crime that the defendant was committed of, she stole a bottle of hair color. It was under $5, maybe $4 or so. They exited the store, her and the female shopper that were with her, got to their car. The shoplifting was witnessed by an employee of the store. Somehow they became aware that they followed them out to the parking lot. While they were in the car, the appellant was the passenger, driver of the car, was lighting a cigarette. Security guards lapsed the cigarette out of her face. She panicked. She begins to leave the vehicle. The officer put himself on the hood of the car when she started to go. Other store employees pulled him back off because that's unsafe and not store protocol. Eventually they were brought to the court and the police station. Eventually they were appointed counsel. The charge was amended minorly and she was convicted. it turned into be a felony instead of a garden variety $4 shoplifting because the car was construed to be the weapon.
I guess I wonder, having spent many years on the municipal court, how that's different from, 80+% of shoplifting cases turned felony. And you're asking us to make a decision that would open the door for all of those people.
But there's more that makes your situation unique. It's those facts on the underlying substance of the case. So even putting that aside, the fact that it's been, it's 98, it's 27-something years ago, she's had no intervening or subsequent criminal activity of any kind. She's not under any current investigation or anything. She's led an exemplary life. And in doing our balancing test, looking at the burdens upon her, this record has haunted and followed her and impeded her in her ability to get gainful employment. She's had mediocre part-time jobs, janitor, cleaning. She even applied at Walmart, couldn't get it because the record's coming up. So it's put a undue hardship on her, and for a very long time. Other reasons, she wants her maiden name back, doesn't really want to go under it right now, because it's more likely to come up with the record. She'd like her maiden name, Duffield, to be on her tombstone. And on the weighing test, then, the state has articulated no reason whatsoever for its reason to keep the record. There's no legitimate.
Well, it doesn't really have to, she doesn't meet.
Under the balancing test, it
Well,
does.
no, what I'm saying is, if she's not eligible by the statute, they don't really have to present a reason, do they?
If you're looking at federal law, you do.
Well, but I understand you want us to look at federal law, but we have a state statute on point, and I think that's at least at the very least, the starting point.
It is a starting point, but it's not the only consideration, because that would be to say you only have state rights and you don't have the federal right in this case.
Well, but the arguments you're making usually pertain, don't they, to somebody who's acquitted?
Under the statute, but whether they're acquitted.
Well, no, I'm talking about the Pepper Pike cases, the cases they're talking about people that are acquitted. And it's a privacy right that comes into play.
Right, on paragraph 2. So it recognized two situations there. The case was decided under paragraph 1 of its syllabus. And in so doing, it also noted 2, which is even when you're statutorily ineligible, you have the federal right. So it's Pepper Pike gives us the vision of what is the truth about the federal statute and our citizens' right to privacy. Even if we never had Pepper Pike, we still have the U.S. Constitution. And nothing that Ohio can do legislatively or case holdings or its applications takes away that right to privacy under the federal. So it's short giving a citizen, when we only look at the statute and not consider, is the statute going too far? Is it being applied to classes of persons such that it's taking away that equal protection of the federal right to privacy? That's where we're at, and that's what's been going on, and that's what is short on all the cases, because it just keeps saying, well, under the statute, you're authorized, you're eligible, you're not eligible, this is included, this is included. If the legislator intended to include it, they certainly could have put it in.
I'm not sure, I was just looking here at the briefs when they were filed, but nobody's addressing that the Ohio Supreme Court case, Radcliffe, I don't believe.
Yeah, I don't think
Decided
I
it
was
last
aware
year.
of it
Or
at
it
the
was
time.
decided just at the beginning of this year.
Yeah, came on January 28th. I don't know exactly when it reached publication, but when updating and preparing again to see the status of the law before it came before you again, I was happy to see this case. Well, I would be happier if it went our way. But the dissent.
Oh, that's what, I'm sorry, that's what you were talking about.
Yes.
While a trial court has inherent power to order an expungement of a criminal record, absent statutory authority is limited to cases where the accused has been acquitted or exonerated in some way. So that's why you're relying on the dissent. I got you.
Yes. So it is circular, exactly like the dissent points out. To only look from statute to statute, okay, applying the statute, still is just blinding our eyes to the backdrop. If there were no statute, she'd still have a federal right to privacy. If Pepper Pike was never decided, her right preceded the creation of the statute in 1981, 1979. It still exists. So to say, well, because we have it now, we're never going to look there again, that's missing the boat. And it's
If you want to save some time, you're going to have to
Okay.
wrap it up.
I'll think
I'm
about
sorry
it.
about
Sit
that.
down and give my, okay, thank you.
Thank you.
Good morning, Your Honors. May it please the Court, Mary Splansco on behalf of the Appellee of the State of Ohio. First, I would like to address, and I believe I got it, was State v. Radcliffe decided by the Supreme Court in approximately January of this year, if I'm understanding correctly. There was no notice of supplemental authority, and I checked the docket as we were listening to arguments this morning, and there was, the briefs were filed in 2014, so the state, unfortunately, is not aware of that case, did not address it in our brief because we could not have, and we weren't given an opportunity to know that the defendant was then going to argue that case. I would point out, just from what I've heard in argument today, and what Judge Carr, you pointed out, is that the defendant's relying on the dissent in that case, which would certainly lead me to believe that then what that case is holding is what the state is arguing here. There's no inherent authority to seal a conviction that's ineligible for sealing. And I say conviction because what that inherent authority in Pepper Pike they talked about was special circumstances, and the special circumstances were the defendant was either found not guilty, the indictment was dismissed, or it was no bill, or the charges were in some way nollied or dropped without there ever being a conviction. And that's not what we have here. This case does not fall under that inherent authority special circumstances. The defendant was convicted of a physical harm specification under former 2941.143, and under the expungement statute, specifically 2953.36C, offenses of violence are not expungible, and the defendant kind of tacitly at the hearing before the court acknowledged that she was statutorily ineligible. So I don't know that that's even necessarily an issue. But I wanted to point out to the court that, the state has briefed and shown that she was in fact not eligible for expungement because of this conviction for an offense of violence. What the defendant is essentially arguing here this morning is that the state statute, and specifically the expungement statute at issue here, is basically unconstitutional because it violates some notion of federal privacy right in having a conviction sealed. I want to point out to the court, and I believe I left a sentence off in my brief where I stopped mid-sentence, and what my point was, and I'll give you the page that I did that at, when I caught it as I was preparing. Well, I'll find it. You'll see it. It's at the end of a paragraph, and it ends. The defendant doesn't establish or submit any case law that states or holds that there's a federal constitutional right to privacy in having a conviction sealed. In fact, as I noted in my brief, the cases that the defendant has cited are cases dealing with procreation, education, medical records, those sorts of things which are fundamental rights that fall under the right to privacy. There's been no indication to show that a defendant has a right to have a conviction sealed under any circumstances. And I believe it is up to the states. When you look at the federal constitution, there's nothing in that constitution that says you have a right to privacy in having a record of conviction sealed if it's been multiple years and you haven't done anything wrong since and it's impeded your ability to get a job. Those are all reasons I'm sympathetic to that. I understand that she has a problem. But that doesn't mean that this court can then, or that the trial court can say, I'm going to ignore the law, and the law is clear. You are not eligible. And that inherent authority from Pepper Pike was actually codified in the statute, and when the court said, and I don't have the site, it's in my brief, but the statute says that if a conviction, if there is no conviction, then the court can grant, and it's at page 7, and I believe it's in the footnote, It's in 2953.52, provides for sealing of criminal records upon acquittal or a finding of not guilty or a dismissal of the complaint. So Pepper Pike has actually been codified by the state, and the defendant has never, other than by reference in arguments today, has never challenged that. They didn't in the trial court say that statute is unconstitutional because it excludes people like me or because it violates my right to privacy. So there's no, I don't think that this court can even really consider that challenge to the constitutionality of the statute, which is essentially where we're at. They're asking the court, ignore the law because my client has sympathetic arguments for why she should get an expungement, even though the state, in weighing a defendant's conviction and an offense of violence conviction specifically, has said, if it's an offense of violence, that outweighs any right the defendant has to have that conviction sealed. And we've codified that by statute and said, if you have that offense of violence, you can't have it sealed.
Can I interrupt you for a second?
Sure.
We don't really, do we have any real understanding or record of what actually transpired in this previous conviction?
Because the defendant pled guilty, there was no evidence presented or anything. And the only thing, and I mentioned this in my brief, is the only thing before the trial court when the defendant pled guilty, and it wasn't even a no contest that there's a recitation by the prosecutor, is the bill of particulars. And in the bill of particulars, what that says is, yes, defendant stole a box of hair color. It was probably $3 and something. She leaves with her friend. They get confronted by a security guard. It's not the bill of particulars doesn't support that the security guard smacked the cigarette.
Right, and that's what I was getting at. I mean, independently today, we don't know that her recitation of what happened is actually what occurred.
Correct.
That's what I was getting at.
And I think that a plea of guilty is an admission to all of the facts, and the only facts that you have are, this is the bill of particulars. It was a document that was prepared by the state, it was served upon the defendant, and the defendant then entered a plea of guilty. And the state's position is, that's an admission of the facts that are contained within that bill of particulars. And the evidence before the court on that, as far as the physical harm, was, yes, the defendant was a passenger in the car, but when this security guard is leaning in to the window and confronting these women and trying to stop them after he's seen them steal this, the defendant tells the driver, go, go, go. The driver then speeds off, striking the security guard, I guess with like the mirror, and he's partway inside the car. He ends up getting knocked to the ground by her speeding away and being injured. I'm not sure what the extent of the injuries were, but that was the basis of the physical harm specification. And I would submit to the court that on those facts alone, you have to say there was physical harm here. So the evidence before the court, although slim, was that the defendant did do that. And that wasn't really even the issue, because the state doesn't have to disprove and the defendant doesn't have to show that the conviction was somehow invalid. That's not what an expungement is about. What this defendant has argued is that the court should ignore the statutory law of the state of Ohio based on some notion that the federal Constitution gives a blanket right to privacy for anything a defendant wants to argue, even in the absence of any case law authority that would say there's a right to privacy in having a conviction sealed on some theory of inequity or unfairness. And that's simply not something that this court should entertain.
So the only remedy really then is a change in the statute.
Correct. And at that point, then she could probably appeal, or not appeal, but reapply for an expungement. And if in fact she qualified, then the court would have to consider it. And then you would come into the balancing of the state's right to keep it private versus the defendant's expectation that she would have the record sealed, or her request to have that record sealed. And that would be the balancing test. This isn't the appropriate place, because the issue before this court is there's a law. Did the court apply it correctly? Not the balancing test, because she's statutorily ineligible. Did the court make that correct interpretation? So it isn't about the fact that she's had no other convictions, that she's led a law-abiding life, all the typical factors that you would consider. And the state, as the court pointed out, wasn't required at this type of a hearing to demonstrate that its reasons outweighed any that the defendant's reasons were outweighed by reasons that the state had for keeping that conviction public, because it's a statutory case, a case of statutory ineligibility. And so under that, guys, the balancing test that the defendant is advocating here does not come in. And it doesn't come in under a question of federal right to privacy, because the defendant hasn't given this court any authority other than this broad notion of the constitutional right to privacy, that they have a right to have a record of conviction sealed. And the state has a right to regulate expungement. It's an act of grace. It's not something a defendant is entitled to. And so therefore, the state would submit that it doesn't fall under any federal right to privacy, just under that theory alone, and in the absence of any authority to show that there is a federal right to privacy to have a conviction sealed, because there simply is not. Based on that, we would ask that the court affirm the decision of the trial court, and it would be incumbent upon the defendant, if she chooses to pursue any other remedy, to seek her legislature to change the law, because that's not the function of the court here. The
Before
statutory
you
law.
take your seat,
Yes.
after this, I was looking again at the journal entry and noted that it does not address any federal constitutional right. And I'm wondering whether, to the extent that the appellant specifically referenced the Constitution and the right to privacy, and the court only ruled on the statutory right, whether an argument could be made that the case should be remanded for the court to consider the constitutional issue.
I don't believe that constitutional issue, as you now bring it up, was really raised or fleshed out in the aspect of a federal right to privacy. I think that's been more an issue on appeal. In the trial court, what the defendant said is, under Pepper Pike, the court has inherent judicial authority to expunge a record of conviction just based on this inherent authority under, I believe as the defendant stated correctly, but the standard was, I wrote it down and now I can't recall. Special or unusual circumstances to seal. That was what Pepper Pike was about. Are there special or unusual circumstances? And in that case, what the court interpreted those to be was that you weren't convicted, it was either dismissed, you were acquitted, or there was a no bill. There was never an indictment in the case. And under those special circumstances, the court had the inherent authority to seal the record of the, I guess, arrest and charge, to seal the fact that the defendant was charged or found not guilty in some way. So I don't think that the case should be remanded for the court to consider the federal constitutional issue, because that was never raised in the trial court, to the best of my recollection. That's been on appeal. It was just a simple reference to Pepper Pike and this inherent judicial authority, which, as I noted, has now been codified, and that statute was never challenged as unconstitutional. Thank you.
I will follow up with that.
Yes.
If you don't care.
No.
Because I really didn't think about that, but Judge Morris raised an excellent point, and that is, he doesn't necessarily address the constitutional argument if one was made, which it may not have been made. But you did just say that, and you're like, be careful what you say.
Yes.
You did just say that, maybe I misunderstood you, but I think you said that they filed under the statute as well as argued that the court had the inherent authority to grant the expungement, and the court really doesn't address that.
What they filed under was, they just said, they filed a motion for expungement, and at the hearing they argued, and I believe it was argued in the motion as well, that under Pepper Pike, the court could grant an expungement even though the statute said the defendant was statutorily ineligible. And I noted that the defendant actually, several times in my brief, had noted what the defense attorney argued at the hearing, which was strictly limited to the issue of Pepper Pike and this notion of inherent judicial authority, and it wasn't based on a federal constitutional right to privacy. I don't believe that that was really ever raised or
But I'm
fleshed
not
out.
sure that's the same question.
Okay,
Okay.
maybe I'm misunderstanding.
No, that's okay. What I'm saying is, let's put the constitutional part aside.
Okay.
That, let's say they didn't raise that.
Okay,
Nonetheless, if they filed basically like a two-part motion, one under the statute and one, and you're saying they're ineligible under the statute, and I know you're saying they're ineligible for the court to do it inherently within the court's power as well. But in rereading this, the court says a defendant is ineligible to have his or her record sealed, offensive violence, and the conviction is statutorily ineligible for sealing and expunsion. The court doesn't say, and I don't have the inherent authority to grant it either.
no, but.
Or I'm not going to exercise inherent.
No, but when you look at the arguments that were raised in the context of that, I believe that the court does appropriately address the issue, because in this case, what the defendant was arguing was that although the defendant, they were conceding, although the defendant is statutorily ineligible, we want you to dismiss it under inherent authority. And the court said, under the statute, I don't have the authority to dismiss it. And I think based on that, that does adequately, although perhaps not in correct verbiage, address the issue that was raised by the defendant, or address all of the issues raised by the defendant. So I think that the court did address it. That the defendant was statutorily ineligible, and the court did not see that they could give that inherent authority, that Pepper Pipe case, any application to the facts of this case. And I would also note for the court that the defendant argues that the standard of review is abuse of discretion. As the Supreme Court held in State versus Futrall, the standard of review is actually de novo. So this court can look at all of that, notwithstanding whether the trial court used the correct verbiage. And under the de novo standard of review, I think that this court has to say there was no inherent authority, and therefore.
And you're out of time.
Thank you
so much. You don't have the full 5 minutes because I got caught up in your argument, forgot to alert you to it, but the state actually went over for about a minute and a half, so I'm going to give you a minute and a half.
All right, thank you, Your Honor. Again, we're right back to where we started from. It's only about the statute, only about the statute. Where's the U.S. Constitution? Where's your federal rights? States cannot write legislation that erases that. If there never was Pepper Pipe, we still have a right to privacy. It predates it, it follows it, it's alive, it's a wow. It must be recognized. To refer to this as a notion of privacy is offensive. The Constitution is real.
I mean, I'll be looking for, as we go through this, what exactly was set forth in any filings that said this statute is unconstitutional as applied, or made reference to privacy interests in the First Amendment, not just some general, let's look at Pepper Pipe.
It is based on saying statutory ineligible under your federal right to privacy, we're asking you to seal the record. It was stated. And this right to privacy can be found in different places. It's not always First Amendment.
Right,
It can
you
be
pointed that out.
14th, it can be. And, you know, to speak to the point of that an expungement and your right to privacy could never be had when you've been convicted. It's also wrong. Historically, throughout history, the courts have done when there's a conviction, and it's especially when it's artificial boundaries, because there was a case, and it's mentioned in the dissent, I think North Carolina, where several black people were arrested just prior to being able to vote, and it barred them from voting for these convictions. So even though they were convicted based on those special circumstances, the records were sealed.
And you're out of time.
Okay.
Thank you very much. The court will take the matter under advisement, and a written opinion will be sent to both sides,
Thank you.
as well as you can look on the websites too.
Thank you, Your Honor.
Thank you.
Very much.